do have skills that make me a nightmare for people like you.
Mr. Merrick.
Is Alison Green. Tēnā koe, Alison. Nau mai ara mai ki tēnei. Tēnei kaupapa. Nau reira tēnei te mihi nui ki a koe. Tō mahi whakahirehire I tēnei rā. So just welcome and acknowledge you for being here and for the work that's been done to get to this point.
And can I insert a requirement of the Inquiries Act to ask you to solemnly, sincerely and truly declare and affirm that the evidence you'll give before this Commission will be the truth, the whole truth and nothing but the truth?
I confirm that. Thank you.
Thank you. Mr. Merrick.
Sir, may I have permission just to approach Ms. Green to put her microphone on? Thank you. Well, just by way of introduction, Dr. Green, ko ai koe no hea koe, so if you can tell us who you are and where you're from.
Tēnā koutou katoa, tēnā koutou ngā mema o te komihana matua, nei rā te mihi, kia koe Chris, tēnā anō hoki koe, kia koutou katoa, tēnā koutou. Ko Alison Green ahau, he uri tēnei no Ngāti Awa, no Ngāti Rangi Nui.
Tēnā koe. By way of further introduction, you've outlined in your brief of evidence some of your qualifications. And in 2018, did you complete a PhD in Māori and Indigenous Development?
I did.
From the University of Waikato. Can you tell us more about what that was about, what the thesis was?
Can I just go back a bit though?
Sure.
Chris? I'd like to say that that I'm a mother of 3 grown children, 2 of whom have recently had their first babies, and I'm raising my 14-year-old grandson who was removed from his mother's care 10.5 years ago. So that's important context for me. So I have a PhD in Māori and Indigenous Development. I researched and compared Indigenous knowledge in health legislation and policy in New Zealand and Canada. And I'm also currently the inaugural postdoctoral fellow at the University of Saskatchewan. And in that capacity, I'm researching alongside a Cree professor from the University of Saskatchewan. We're comparing the removal of Indigenous children in both polities.
And do I understand it that postgraduate fellowship or postdoctoral, fellowship will effectively travel alongside the life of this commission?
Yes, it will. That's right.
In paragraph 4, you outline some of the work that you're doing for Ngāti Awa. Can you tell us about that?
So I'm currently the chair of the Ngāti Awa Community Development Trust. So we look into the issues of social development, so health, housing, education, community development in general, as well as the development and maintenance of our reo and our tikanga for Ngāti Awa. But I have also done a couple of pieces of work for the tribe, and so I, in 2007, spent time working for Te Runanga o Ngāti Awa, looking at the co-production of social policy. And that was a very an interesting piece of work. So again, we were looking at how we as an iwi might influence legislation and policy, in particular social policy, so that those worked well for our people, whereas historically they haven't, and of course that's been the domain of the Crown and not Māori. And the other piece of work that I did, which is somewhat touches on the work of the Commission, or the brief of this Commission, was looking into offending and victimisation involving Māori, both as offenders but also as victims in the Mātātua region. So I was looking at how those statistics, at why Mātātua were overrepresented in those negative statistics. And that report was peer-reviewed by Professor Tracy McIntosh, who will be with the Commission in a few days.
Just for those who aren't familiar, for those that aren't familiar, the Mātātua region, Te Rohio Mātātua, can you just explain that for us?
So that region would cover what is called the Bay of Plenty region, so right up the coast, and then down into the bowl around the Tauranga area.
Kia ora. You come to it later in your brief, but we acknowledge it up front. At this stage is a piece of work that you did in 1992 for the Human Rights Commission. Can you just briefly tell us about that piece of work? We'll go into detail later on.
So in 1992, I co-researched and authored a report with Pānia Alison. The report was titled "Who Cares for the Kids? A Study of Children and Young People in Out of Family Care." And the report was done in two sections. So there's a Māori section, and then there's a Tauiwi or Pākehā section. And Pānia and I did the Māori section, which we can talk about later.
Yes, and it was the Human Rights Commission that commissioned that report at that time?
That's right, it was.
Now, turning back to your brief, and we're on page 2 now. We're still on page 1, and really I did want to ask you about two things. First is your involvement in claims before the Waitangi Tribunal. Can you tell us about your involvement in that tribunal?
So I am party to a claim, that's claim 2494, and we've recently, and I'm party to that claim because my whānau have experienced 3 generations of removal involving Department of Social Welfare, then the Child, Youth and Family Services, and most recently Oranga Tamariki. In my statement of claim, I'm concerned at 2 levels. I'm concerned about the factors which predispose some Māori families to the removal of their children at rates that are far higher than those than our population would suggest. And the second aspect is the way in which the removals happen, and in particular, those removals happen as an arranged, that they happen without the involvement of hapu and the whānau more generally. Thank you. And can I add, Chris, that we've just been advised that particular claim and 2 others will be heard with urgency, and I think that speaks to the the critical issues that children, Māori children, are facing right now. So although it's valuable to have this broader, the scope of the tribunal, I think it's also important that we consider the rights of Māori children now.
We're on page 2 now, and I suppose as a starting point for you to share with us your experience in going into in being removed from your whānau. At paragraph 6 of your brief, you start to talk about that, and if you could start to share with us from that point would be great. Thank you.
So I am the eldest of 7 children. I was born in 1958, and I was removed soon after birth and raised by Pākehā parents. My parents who raised me were recent immigrants to New Zealand. And the consequence of, so I was adopted under the 1955 Adoption Act, and it was a closed adoption, and as a consequence of that I was separated from my whakapapa, whenua and whānau, and those had traumatic consequences for me through my early life, and I'd say they still have consequences. They do.
Did you come to learn some more about the circumstances of you being born and then adopted? What could you tell us about that today?
So I was adopted, and around about 10 days after I was born, I was taken by my adopting parents to the far north. They told me later that they were advised by the social worker to say that I had a touch of Spanish, and that my birth parents no longer wanted me. And I was told by them that there was no way that I could, by my parents, this is my adopting parents, that I was unable to make contact with my birth parents. In fact, I'm really uncomfortable using those terms, birth parent and adopting parents. I think those are, the terms themselves are probably precursors as well to, or probably justification for removal through the closed adoption process. The idea that you can be a birth parent, but that parenting and that relationship can end at birth, and then you can pick up with somebody else. Yes, my parents, with my birth mother, so my birth mother was Pākehā, father Māori. My father and my father and mother met at a dance in Tauranga. They dated for around about 8 months, and then she became pregnant, and out of the stigma that accompanied what was called pregnancies out of wedlock in those days, she went to Auckland to her parents, where she was persuaded both by social welfare but also I think by her mother that it was in her best interests and mine that I be given up for adoption. She had been told by the social welfare that if I was able to live my life as a Pākehā child, or certainly not as a Māori child, that my outcomes would be better. And so I guess the touch of Spanish kind of accounted somewhat for the fact that I was a small, brown, round dark-haired child, and they needed some way to account for that.
Are you aware of the practice at the time of establishing a hierarchy in terms of the adoption system?
Yes.
And do you have any comment about that and how that, on reflection, has impacted on you and your circumstances?
So my adopting parents told me that they had been, because they were recent British immigrants to New Zealand, that they were given the bad babies and the hard-to-place babies. And the bad babies were the Māori babies, and the hard-to-place babies, in the case of my adoptive sister, who was Pākehā, were babies that were not expected to live. And that was her situation. In fact, she did live, but that was the hierarchy as it was explained to them.
At paragraph 9, you've made reference to growing up in Aotearoa without whakapapa whenua and whānau. I'd like us to unpack that a little bit in your own circumstances. And as a starting point for that, can I ask you how societal attitudes of that time, much like what I'd describe as a racist hierarchy of adoption system, how that impacted on you growing up across the board, schooling, and that sort of thing in terms of your identity? Yeah.
I want to liken this to my experience to the Pipi Wharaurua. So the Pipi Wharaurua is a migrant bird, the shining cuckoo, and it migrates from the Bismarck archipelago, so from Papua New Guinea and Melanesia. In spring, it migrates to New Zealand, and it looks for the nest of the riro, or the grey warbler, and it lays its egg in that nest, and then it flies off, and the riro raises the Pipi Wharaurua chick, and then, but here's the rub, and here's the Māori understanding of the situation, is that the Pipi Wharaurua is always a Pipi Wharaurua. The Pipi Wharaurua does not become the riro. And so, for me, I was raised in a nest by Pākehā parents, but I remained myself. And there is a sense, no, it's more than a sense, there is a belief in this country that when children are removed and raised by somebody else, that they will become somebody else. I can tell you that is not so. But what you're left with are remnants of who you could be and who you would be had you been raised in the environment, in the nest that you should have been, that you belong to. And so I had a very unusual childhood, in that I knew that I was adopted, and I knew that I didn't belong in this nest, and that I belonged somewhere else. And that journey of finding out where I came from and where I belonged was a lifelong journey. And, you know, so that requires, it requires a lot of hard work on my part not to lose focus of who I was meant to be, and importantly, the original instructions of my people for their people and for us going forward. So, so without those original instructions, which I'll talk about later, Chris, but without those, it's hard to find a path. You don't really, the path doesn't open up naturally for you. So in order to reach one's potential happens much later, I think, than if the child is raised where it belongs, in the whānau, in the hapu, and with the iwi. So things like, so I know now, for example, you know, when I go to my home territories, there is a feeling about standing on those lands, about seeing, looking through my eyes at the view that my tupuna would have seen. Those are powerful feelings that I wasn't able to access during the early years of my life, and only later when the Adult Adoption Information Act 1985 came into being, and then I could begin that journey back.
And so, looking at that journey back, what did the Adult Adoption Information Act 1985 allow you to do? What happened from there for you?
Yes. So before that, I'd approached social welfare on at least 2 occasions and asked if I could be given even non-identifying information, but information that would allow me to say, in answer to the question, no hea koe, I could say, no tauranga ahau, no whakatāne ahau. And that would be at least some sort of toehold into that journey of belonging, but I was refused on both occasions. So finally, when the legislation changed, I think, you know, fairly well forward in the queue of people writing to social welfare to ask for my file. And it was my good fortune that my birth mother hadn't heard about the legislation, and so hadn't had an opportunity to prevent access to the file. I don't know whether she would have. I'm unsure about that, but certainly it made it much easier. So that happened in 1985. I think in 1987, might have been, that I first spoke to her. And as we corresponded first, and then we talked on the telephone, and she was able to provide me with the information that I needed. And we had contact with each other for a period of time, but she experienced post-traumatic stress syndrome at my separation, related to the adoption. She was having flashbacks and panic attacks, so we stopped further communication. But I found out that she had another child after me to a Māori man, and she kept that child despite the pressure to give him up. And for her, that was a healing point for her.
And so, have my math right, I always get it wrong. By that stage, you're 21 or around 21 years of age before you've had that opportunity to access that information.
Yes.
Yeah. And prior to that, you've been denied that.
Yes, I was. So I moved from Epsom Girls Grammar, where I did my secondary schooling, and I got there through a Māori Affairs scholarship, and in a boarding school, and then went to Victoria University and did a degree in Te Reo Māori and anthropology. And of course, you know, it was, this was the days of the, following the Land March, and a general Māori sort of an uprising of Māori across the country. And so, you know, we were concerned that the Crown had not honoured the Treaty of Waitangi and of course Te Tiriti o Waitangi, most importantly. And so we were I was involved in Māori activities all through my university undergraduate degree. And I, you know, the question was asked of me all the time, no hea koe? And I didn't have the answer as an 18-year-old student. And for that reason, Professor Hirini Moko made this, and his wife made a tremendous offer to whāngai me in order to provide some sort of resolution, albeit temporary, to that trauma of being removed and not having whakapapa and whānau and whenua.
So, can we turn now to ki tō taha Māori, tō pāpā, to your dad's side. Tell us about exploring that avenue and finding out about that side of yourself.
Yes. So when I found out the name Mason, I immediately contacted my professor, Hirini Moko, and said to him naively, do you know the Mason whānau from Tauranga? And he said to me, well, actually, they're from Whakatane, but there are some Masons in Tauranga. And he said, actually, your koro sits in the office next to me. He's the general manager, he's the whakapapa expert, he's the person you need to talk to. And so it was this, you know, this is, I think, where the Pākehā Western world, with its objectivities and its focus on what can be seen and what can be measured and described, and the Māori world separate. So the fact that Professor Mead had come to me and made this offer, the fact that we were already closely related but didn't know, to me was evidence of those things that are unseen, which for us are as important, if not more so, than what can be seen and described. The rest of my years have been spent building the relationships that I wasn't able to build as a child, as a young person growing up with my whānau. My aunties, so my father's sisters and brother, were so generous, so welcoming of me as the eldest child of my father, who had passed by the time I went back into the family. But their generosity of spirit on my Ngāti Ranginui side and on my Ngāti Awa side was so reassuring and grounding for me.
Spoken about the importance of the unseen, and then you've also just mentioned the passing of your father, and you've talked about it in your brief. He kōrero au mō tēnā, have you got some things to say about that aspect of your brief?
Well,
your kōrero, your story, your life?
Yeah. So as soon as I knew, but to go back, when my father passed, he passed a few kilometres from where I was at boarding school, and I knew he'd passed. Don't ask me how, but it was there, and as have been many other things that have happened since then. Sorry, Chris, I've lost my place. Yeah.
One of the things that you've talked about in your brief is the extent to which you've, through your father's connection, learnt about the whakapapa of your whānau. And if I can describe it as the breadth and depth of it. And that's described at page 3 of your brief. In particular, you've talked about some of your tūpuna, some of your ancestors.
Yes.
Can you tell us why you chose to include them in your brief of evidence and in your kōrero for us today?
So anyone who knows anything about whakapapa would know how tricky it is to come to understand the different lines of your whakapapa. So you would choose, so if you were talking about your whakapapa and you were in a particular area of the country, you might use another line of your whakapapa than you might were you at home. And that's in order to indicate the relationships that your tūpuna have with the people of the land upon which you're standing. So I wanted to show that it takes a number of years to amass that information. You gather it from people who are respected in your whānau, and I was very lucky on my Ngāti Awa side, so that's my grandfather's side, to have Koro Joe Mason as the source of my information. And of course it's always useful to go to the Native Land Court minutes to read about one's tūpuna. And you know, on my grandmother's side, which is my Ngāti Ranginui side, my father's youngest sister, Deiwi Pearson, gave me that whakapapa. But the other point of having the whakapapa in my brief of evidence was to highlight two, for today anyway, two members of my two tūpuna who were well respected and well known in my tribal areas. So Te Mono Tāhuna on my Ngāti Ranginui side was a composer of waiata, and to this day Ngāti Ranginui sing and perform the waiata that she wrote for her illegitimate daughter, Matatu Mono Tāhuna, and she wrote that the term illegitimate is a Western term. For whatever reason, Mono Tahuna didn't name the father of her child. But she wrote this waiata to celebrate her, the absolute adoration that she had for her daughter. And my new mokopuna, so my eldest daughter's child, she has named her Matatu, after Matatu Mono Tahuna. So on my Ranginui side we have Mono Tahuna. On my Ngātiawa side I've referred to Pauwha Meihana, my great-great-great-grandfather. His statue stands on our marae. He was, his claims and his counterclaims are through the Native Land Court minute books from the period from the 1880s. He was a stalwart and a forthright defender of te mana o Ngātiawa me te mana o Ngāti Pūkeko. So that was my tūpuna, and it absolutely horrifies me that from the 1970s onwards the state saw fit to remove 3 generations of children from whānau of respected tūpuna. And so that is the point of having that information in there, to provide that contrast.
We're going to head in that direction shortly, but before we move away from our kōrero about whakapapa, I wondered if you had any comment about given the time that you were effectively disallowed to live in that whakapapa, to really experience it, and now having learned all of that, if you had any reflection about the lived experience of being part of that wealth, of cultural wealth and whānau wealth, whanaungatanga, compared to having to come in later and learn about it and experience it later in life. Have you got any reflections on that?
Well, of course, the whakapapa is, as Rawiri said this morning, it is relationships. And so while I have the words here and the names, some of the richness can never be retrieved. You know, I wasn't party to conversations, to events, to tribal gatherings where people were regularly talking about the deeds of our tūpuna. So I've come to that much later in life, and that's something that cannot be regained. And for that reason, I have made it pretty much my life journey to make sure that my children and my mokopuna, so the children of my siblings and their children, that they never experience what I went through. Because although I went through it in a closed adoption system, effectively those who have been removed by the state from the 1970s and 80s onwards are also experiencing that poverty of relationship connected to whakapapa.
We are now at paragraph 16 of your brief of evidence. And can you share with us your thoughts about the impact of colonisation within your whānau hapuiwi context?
Yes. So on my Ngāti Ranginui and Ngāti Awa side, there are the reports to the Waitangi Tribunal that document the confiscation, the raupatu, of thousands of acres of land that both of my iwi experienced, and the effects of that in a socio-economic sense, but also in terms of the lack of political authority or mana within our region. So those breaches, so the tribunal found for the claimants, so for both tribes, and were very clear with the Crown that they had breached Articles 2 and 3 had breached Te Tiriti o Waitangi. And so I'm alleging, and I will do this in my claim to the Waitangi Tribunal, that breach of Te Tiriti has extended, that the Crown has seen itself as able to breach the Te Tiriti o Waitangi in relation to the removal of our children. So the Crown has seen itself as having the right to remove our children, either through closed adoption or through uplift, and placement in uplift, and that view is a breach, I believe, of Te Tiriti o Waitangi. And of course, Te Puao o Te Atatu, and this is an original copy of the document, recommendations 1 and 2, which I can talk about later, but certainly highlight the right under Te Tiriti o Waitangi of Māori to care for and raise our taonga, our children, ourselves, within our authorities. So I'd also like to comment on the part that racism has played in my adoption, but also in the removal of my nieces and nephews and grandchildren. So it seems to me that there is a shameful silence in this country, that those of us who've been removed from our families under the adoption legislation, that we have laboured under that shameful silence, and in fact we have adopted that silence ourselves. That there has been very little about the impact of closed adoption on Māori children, on the loss to hapu and iwi, and that to me speaks to racism in this country. I think that if the same were happening for tauiwi, that there would be a public outcry, both about the removal of children by Oranga Tamariki, but also the closed adoption system and the loss of potential of children to Pākehā families. But because we are Māori, that has happened with very little interruption until recently.
And so when you say tauiwi, you mean non-Māori in that context? In your brief of evidence from paragraph 18, you talk about some factors that you would argue have created whānau vulnerability to child removal.
Yes.
In your summary, what are some of those factors in the context of your whānau, your hapu iwi?
So years and years of legislation and policy and poor practice across the whole range of social and economic and political, across the spheres, have the cumulative effect of that, part of which is dealt with in the Waitangi Tribunal reports, but the more recent material has not been dealt with. But it is that legislation, policy and practice across the social, economic and political spheres that have reduced some Māori families to the point where we are extremely vulnerable to the removal of our children. This didn't happen overnight. My nieces and nephews who've had their children removed, they were not in a position where they were, where they had assets and resources as part of their daily lives, knew where they were from, well grounded in their tikanga and reo. They did not suddenly find themselves with oranga tamariki knocking on their door. They themselves were removed from my siblings, who were removed from their families, and the poverty, so poverty, addiction, living in neighbourhoods with where there's high levels of crime and violence. Those, so most recently, the availability of methamphetamine. These are the antecedents to removal of children. But it didn't happen overnight. It happened, successive governments allowed the situation to come to this point. And that is the point that my nieces and nephews and my grandchildren find themselves in today.
What you've begun to touch on there is the move from the papakainga to the cities, or from the rural, the home base to the cities. In paragraph 24 of your brief of evidence, you've touched on that in terms of your earlier kōrero about the loss of land.
Yes.
In your home.
Yes. So can I read? So in 1891, Pope described the lands of Ngai Tamarawaho, that's Ngāti Ranginui, as little in quantity and poor in quality. These natives live a miserable existence at Huria, endeavouring to get some return for their ungrateful glebe, or working precariously for neighbouring Europeans, or working out their constitutions on the gum fields. So that is a report about my hapu Ngai Tamarawaho in 1891. Things were that bad. We've had, nearly 200 years of legislation and policy, and that poverty has been further entrenched.
Back to your siblings, you've discussed their entry into the state care system from paragraph 27 of your brief of evidence. Can we pick up from that point?
After my father died, he died at 32 years of age. And suddenly, after he died, my children's mother made the decision to leave the papakainga at Huria, Ngai Tamarawaho lands, and take my siblings with her to Wellington. She moved for work reasons, but without the support of whānau, of elders, people who knew not just the negative things about ourselves as was written in 1891, but also the strong and positive things. Without that, my siblings, my sisters and brothers, faced many, many challenges. And to the extent of being put into homes and foster care. And through that separation from our homelands, although they are fiercely proud of being from Tauranga and of being Māori, the specifics around whakapapa and whenua and whānau in its Māori sense, not just mum and dad, but whānau in a Māori sense, that information has not been available to them. And so that, in combination with poverty and a school system that failed all but one, failed 5 out of 6, their lives, the trajectory of their lives was set for real difficulties. And I made the point in my brief of evidence, that this was a time when New Zealand was experiencing its good years. This was the Pavlova paradise. We were not part of that. That is racism. So the culture and relationships of gang life, addiction, poverty became constant features of my sisters and brothers' lives, and those have remained.
Now I'll just turn to the chair now, because we're pretty close to 1 o'clock, sir.
Yes, I think that might be a convenient moment for us to take an adjournment. The stenographer has been in full action for a lengthy time. So, Dr. Green, if you don't mind, we will take an adjournment now, and we'll return to your evidence at 2:15.
Thank you.
Thank you. Thank you. Madam Registrar.
Kua hiki tēnei no moanga, tēnā koe e tū. The sitting is adjourned, all stand.
Dr. Green, just before the break, I think where we ended was you were talking about your siblings and the role that state care had in, I think the words you used, their life trajectory. We hear a fair bit about the path from state care to prison, and I wanted to ask you whether that was a path taken by any in your whānau.
Thank you, Chris. Yes, it is a path that 2 of my siblings have found themselves, are on. And given the harsh circumstances of their lives, it isn't surprising. But it's also a trajectory that I'm concerned some of my nieces and nephews may also be on. So these are children who were removed from my siblings' care. So yes, that pipeline is well and truly established in my whānau.
Before we go on to talk about your nieces and nephews and their tamariki, I want to pause on the period of around 1988, and you've referred to Puao Te Atatu in your brief of evidence. And so we've heard yesterday about reports being shelved, gathering dust, things like this. And Puao Te Atatu is said to be one of those. Did you want to share with us today your thoughts about that in the context of your journey?
So, what we know about Puao Te Atatu is that the engagement between the committee, the advisory committee that developed the report, and Māori communities across the country was a close one. So there were, I think there may have been 65 or more hui held with Māori, and the voices of Māori are absolutely, you can see them in the report. They're reflected in the recommendations of the report. And at the time, the support from Māori communities, once the report was released, was strong. But after that, there was silence, and then I had occasion to be doing work for the Human Rights Commission, and the tangata whenua, the Māori communities that we were consulting with, were saying, well, what about Te Puao Te Atatu? You know, we told everybody what we thought needed to happen in order to make sure that that hapu and iwi were maintained, that hapu and iwi had authority with regard to tamariki Māori. But what is happening in practice is light years from our recommendations.
Before we go on to talk about that report, the Human Rights Commission report, which you describe at paragraph 30 of your brief of evidence, have you got some things to say about Puao Te Atatu in the context of closed adoption?
So, in relation, I have got things to say about closed adoption, but also about the removal of my siblings, their children, and my nieces and nephews. So, in relation to closed adoption, Puao or Te Atatu was very clear that any decision about the placement of Māori children, and they actually said, including adoption, should be made with hapu and iwi. And that the 1955 Adoption Act is exactly as it is now, as it was then. So we know that Puao Te Atatu had no influence over that particular piece of legislation. And in relation to my nieces and nephews and those who've been removed from our family, again, so actually, recommendations 1, 2 and 13 referred to this kind of systemic changes that legislation should create in Aotearoa in order to remove the burden of poverty, of failed education, of lack of housing, of Māori engagement with tikanga and te reo. Those Puao Te Atatu recommended that legislation should address those issues. And I contend that had subsequent legislation addressed those issues, that some of my nieces and nephews may not have been removed, because poverty, drugs and alcohol, exposure to violence and abuse would have been addressed through those systemic changes, but they weren't.
And so that leads me now to ask you about this Human Rights Commission report that you co-authored the Māori research component to. Now, if I can just pause there, because that report has only just come to hand, and I just want to check that that has been circulated to the commissioners. I know Council have copied that. Well, what I intend to do is just to touch on some aspects of the report with Dr. Green, read where relevant sections of that, but without diving too deep for too long this afternoon on that.
Will it be sent electronically to us?
There is an electronic copy that I had hoped was circulated already by now.
All right, you just touch on it briefly and we'll look at it later.
Thank you. So can you, Dr. Green, just outline the background to that report, which is called Who Cares for the Kids? A study of children and young people in out-of-family care.
So I could do that most effectively by just reading the first paragraph, I think. So the aim of the report was to examine the issues concerning the placement of children and young people who, for various reasons, are being cared for outside their immediate or extended families. Information is gathered about how and whom decisions are made for out-of-family care placements and what happens during and after placements. The report also describes the perceptions of young people themselves.
And that report was commissioned by the Human Rights Commissioner, and the foreword signed off by the Human Rights Commissioner of that time.
That's right.
Can I refer you to page 1, which is under Chapter 1, Introduction, and there's reference there to the United Nations Convention on the Rights of the Child. But in particular, because of what you're talking about in your evidence today, I just thought it might be useful to read the paragraph which outlines Article 30 of UNCROC. If we can use that abbreviation for it.
So Article 30 of UNCROC addresses Indigenous rights. It states that children who are Indigenous shall not be denied the right, in community with other members of his or her group, to enjoy his or her culture, to profess or practice his or her own religion, or to use his or her own language.
Now, you spoke earlier about Article 2 of Te Tiriti o Waitangi. Have you got some views about how the two sit together?
So the Māori understanding of Article 2 would be that children are taonga, and that they in relation to hapu and iwi members, should not be denied their own culture, their language, or any other practices or beliefs that they have. But in fact, that is what happened. So that has happened for those of us who were part of the closed adoption process, and it's happening now for Māori children removed from care.
Can I pick up on one piece of feedback that you have included in paragraph 30 of your brief of evidence? And I'll just read it out. It's touched on in the report, but in that you've said part of the feedback was this: it was found had resulted that Puaoteata 2 had disappeared from the corporate plan of DSW, and that had resulted in lack of commitment by DSW to any real bicultural development. Instead, a superficial involvement in such development exists, one that generated more negative than positive responses. And you've referred, and this is where I want to pick up on our discussion about Article 2 and Article 30 of UNCROC, is where one participant says Māori concepts like aroha have been hijacked by DSW, trivialised and then used against us. And that's found on page 91 of the report we're talking about. And my question for you is, the answer is probably obvious, but the discussion is important because of this question of who is best placed to ensure that rights conferred in Article 30 to Indigenous children, who are taonga, mokopuna, under Te Tiriti, Article 2, who's best placed to ensure that those rights are nurtured.
So of course, Puao Te Ata 2 were very clear that those best placed to make those decisions and, in fact, to then implement those decisions were hapu and iwi, of which whānau are a part. Puao Te Ata 2 were made a distinction between what might narrowly be called, what in the West might be called parental rights. They described those as being best considered with regard to the rights of the collective. So not necessarily one or the other, but certainly not simply the rights of the state, nor the rights of parents, but the rights of the collective.
Take you now to the Māori section of this of your report, which I know you co-authored with Pānia, Alison.
That's right.
That's at page 75. And the title of that is Te Muringa Tamariki ki Kāinga Tauhou. What have you put as the English title for that?
So the term muru is used to, in some context, and it's being used this way in this context, to refer to confiscation, as in which has a sense of punishment. So raupatu and muru are often discussed in this way. So the report is called Te Murunga Tamariki, so the confiscation of children, ki kāinga tauhou. Now tauhou means strange or unusual or different. So the title altogether means the removal or the confiscation of children to the homes of strangers. And that was, the title was proposed by well-known kaumātua Ani Delamere, but it was supported by the advisory group that was involved with this project. And so there's an English translation as well. Well, it's not a translation, an English interpretation. So the subtitle is Misplaced Māori Children and Out of Family Care. And that comes from a quote by Nada Poe, who some of you will know. Nada said at one of the consultation hui that we held with tangata whenua, our kids are not being placed in out of family care, they're being taken off us and misplaced. Now that was 1992. The same practices are happening now. And this was after Te Puao Te Atatū. Nothing had changed in that period between the production of this report and the work we did in 1992. So I think what we can see there is a solid line of continuous action of hapu and iwi being denied a right in the care of their children, and in a taking a confiscation, so a form of punishment of our Māori communities, taking our children and placing them with strangers.
In terms of tangata whenua consultation at page 81 of that report, you list that hui were held with tangata whenua groups, and you have listed those groups: Ngāti Kahungunu at Waipatu Marae Hastings, Ngāti Koata, Ngāti Kuia at Whakatū Marae Nelson, Tainui at Makaurau Marae I Humatao, and Ngāti Whātua at Puatahi Marae Kaipara. Can I take you to the bottom paragraph of that page? Because there was somewhat of a prophetic feedback, wasn't there, from Ngāti Koata and Ngāti Kuia.
That's right.
Can you read the portion starting some weeks? Oh, sorry, the only.
The only hui tangata whenua not to propose recommendations was the hui at Whakatū Marae Nelson. Some weeks after the hui, researchers were told that the people at the hui in Nelson were so disillusioned by the powers that be that they did not think it a worthwhile exercise for them to propose recommendations which would not be heeded.
Because it was one of the goals of your group to come up with recommendations from each of the hui tangata whenua.
That's right.
And you've included those in the report, haven't you?
Yes, we have.
Now, you said just before that some of the things that were said, that have been said now about this issue are what was said back then. Do you have a summary for us of some of what that feedback was during this report?
Some of the issues that came from the tangata whenua hui were as I've just described. So although Whakatū Marae withdrew from, they decided not to make recommendations. The other groups made recommendations that were very, very cynical of the likelihood that the Crown would make changes. So they made those recommendations, but they were very cautious that it was unlikely that change would happen. And so that was the tangata whenua hui. Parents whom we interviewed about their children who'd been placed in out-of-family care had a number of recommendations. For example, they commented that in their interactions with the Department of Social Welfare, Child, Youth and Family, that the emphasis was always on removing the child. There was no emphasis placed upon what support the child would receive once it was removed, what support the whānau would receive once the child was removed, and what the kind of what outcomes could be guaranteed that would be better, perhaps, than those of the child's situation right now. So parents had low levels of confidence about what was happening for their children, but they had no right, no ability to prevent their children being taken.
What about the views of the young people themselves? Did you canvass those?
Yes, we did. We met with young people. It was a difficult exercise because, asking young people questions. There are ethical responsibilities that researchers have, not to overpromise. And in fact, when you asked a young person, so I recall 2 young people that we interviewed at Weymouth, which was like a correctional facility for young offenders. I remember the young woman saying that she was worried about what was happening back home and whether people would be all right, everybody at home, were they all right, because she had no communication with her family. And I remember a young man who I felt gravely concerned about. His perspective was, what's the point in me saying anything? No one's ever listened to me. I expect, my uncles, I've got more family in prison than I have anywhere else, and that's where I expect to be. And as a researcher and as a Māori, first and foremost, one could not dissuade him of a situation which actually he'd predicted fairly accurately. And interestingly enough, Chris, this report has not received very little attention in the public eye. And it took me a while to get a copy. I didn't have my own copy, so it took a while for me and for the Human Rights Commission to track it down. But I think that it behoves us as people involved in this area of work to, as Rawiri said, make sure the light shines on the voices of these young people and family.
That being said, did you want to produce that report as an exhibit in this?
I would very much like to do that. Thank you.
So can that report be exhibited as Exhibit 3? Earlier you touched on lack of intensive support or wraparound support within the whānau, as opposed to there's a removal response and then a response that's required in the whānau to support those there. Is that a theme that comes out if we were to look at the story or the life of your nieces and your moko?
There is, so again, the focus has been on the uplift of Māori children. It's certainly not, at least on Oranga Tamariki's part, certainly not a focus on how to alleviate intergenerational poverty and all of the issues that go with that. So if one interacts with Oranga Tamariki around these issues, the focus, the response is usually something along the lines of, that's not something that we can address. Thank you for bringing it to our attention. So no advocacy. And when I think about my nieces and their children who were removed, so children are taken 10.5 years ago. from one family that I'm thinking of. 3 children, a 2-week-old baby, a 2-year-old and a 4-year-old. They're taken to the bottom of the country, miles and miles away. The parents are told that they can keep in contact with the children, but over the years the phone calls dwindle, the letters dwindle, the correspondence from Oranga Tamariki about the welfare of the children doesn't reflect at all the children's reality, which has since come to light. So the children were reported as thriving, but I would dispute that. So, yeah, and, you know, the mother is asked to go on a parenting course and repeated parenting courses with no hope of ever having those children back. How inhumane is that?
One of the things that comes out in your brief around your nieces, nephews in Mokopuna is the issue of what happens on transition back. So would you have some things to say about that, on returning home and the department saying, yes, you can go home, and what happens there or what doesn't?
So just going back a bit, so, you know, if we think about those antecedents to the removal of children, so those are systemic issues, so they're multi-generational, so poverty for one, poor housing, violence and abuse. Those issues sit within families, but there's no attempt to work with whānau and hapu to address those issues, so that by the time the children return, there's an environment which is more conducive to the kind of parenting that traditionally Māori that we did. And so, you know, Oranga Tamariki returns children it's like the Mr. Bean picture. They're dropped into a location. Nothing has changed around it because there's been no support or resources or advocacy for change. And then Oranga Tamariki, as it seems to me, watch and wait. And then the inevitable happens, which is things go wrong, both for the children who have not had a relationship with the parent for over a decade, and for the parent who's stuck in the poverty trap. So things go wrong, and then Oranga Tamariki sweep in and uplift again. It's devastating.
Surely I want to ask you about your hopes for this Royal Commission as we come to near the end of your evidence today. But before then, I just wanted to offer you the opportunity to add anything more which you would like to say of any of those matters, particularly in relation to current practice, the impact that it's had on your moko, your nieces and nephews. So I'd, in terms of closed adoption, a change of legislation is required. So Māori children we should not be seeing Māori children put into or adopted outside of their whānau or hapu or iwi. So there's lots of scope there for placing children when mums and dads make the decision. And really, this shouldn't require state intervention as it is now. And so
in my mind, so I'm not a fan for tinkering on the edges of legislation. I think what is required is substantive change in the way that power is held at the level of government, and also then who gets to make legislation and policy and who practices that in this country. So I would like to see, I think it's important for Māori that Māori have the opportunity to overhaul how adoption happens for Māori. I talked about the shame and the silence that has accompanied Māori who are adopted out of their family. And so because of that shame and silence, I think we have to have a thorough engagement around the issue, perhaps something akin to a commission of inquiry specifically for adoption. There are hangovers for the adoption, for those of us who were adopted. Te Reo Whenua Māori Act needs a real good look, and so discussions need to happen within Māori communities around the issue of succession of land interests for Māori who have been removed from families. It's not an easy process to be able to succeed under the current legislation. So even if you know your whakapapa, it may be that the Māori parent died, and it is insufficient, and that it's difficult to bring together information to support an application for succession. So that needs to be dealt with. In terms of removal of children from care, again, I would say that that the Crown is, in removing Māori children, is breaching Te Tiriti o Waitangi. And we need to reconsider the issue from the perspective of Te Tiriti, and I know that my colleague Moana will talk in more detail about this. In relation to that, those antecedents to the removal of our children urgently need addressing, because unless those are addressed, the burden of poverty, the burden of marginalisation, of violence, of abuse will continue to fall on our families. And as I've argued, this is not because we are more likely to be to fall into this area, but because government policies have pushed us in that direction.
Now, just to finish, at the head of your brief of evidence, you have included a whakatauki, a proverb. Would you care to share that with us, and tēnā whakamārama mai o whakaaro mo tēnā? So please explain why it is you've used that whakatauki in particular.
So it's spring, well, we're starting to move into summer, and at this time of year, the kuaka, or the godwit, returns on a journey of 18,000 kilometres direct from the Arctic to Aotearoa. And the godwit has been doing that for thousands of years. And the map for how to return home is in it. It is part of its makeup. So although it's born, the eggs are laid in the Arctic, the bird hatches there, but it knows how to get to Aotearoa. So I chose a whakatauki, which is about the kuaka, or the godwit. He kuaka mārangaranga, ko tahi manu I tau ki tāhuna, tau atu tau rā. And I chose that because the whakatauki speaks to one godwit arriving from across the ocean and landing on a sandbank, tāhuna. And as soon as we see one, we know that more will come. And we know that will happen around this time of year. And I've likened that to the voices that we have here at the Royal Commission of Inquiry hearing. The voices are, there's a small number of voices, but eventually the voices will grow and this country will become aware of the injustices that have been done. And so I'm hoping that those of us who have given evidence will be like the early godwits and that we will be followed by others and that all together change will come. Kia ora.
Nō reira, e mihi ana ki a koe te manu tai ko I tō mahi, tō kōrero I tēnei ahi. Thank you for that. Thank you very much. I'll just pass over now to the Chair.
Thank you, Mr. Merrick. Have any council conferred with you, Mr. Mount, about cross-examination of Dr. Green?
No, they haven't.
Right.
Yes.
I sent emails on Sunday, so I got the email at lunchtime.
Certainly. Please proceed.
Kia ora, kei te mihi atu a koe. Te whanaunga a mai Ngāti Mākino, kei te mihi atu ki a koe. Te whakapapa anō tāku ki Ngāti Awa, he uri anō o tai whakaia Ngāti Hikakino, uri taua tūmanako. Kei te mihi atu au ki a koe, ki tō whānau. Me tō kaupapa whakahirihira I noi a tātou. There's two matters I'd like to explore because I think that most of the others have been covered. The first is a matter of cultural prejudice that arises from land dislocation for those that are in closed adoptions. And one of the concerns, and it's been an ongoing concern, is the Ture Whenua Māori Act, and even the fishery settlement processes can actually work for those that have been taken out of their whakapapa and placed into placements with strangers so that they aren't entitled to benefits that are being accrued by some of the processes that are addressing colonisation. Are you familiar with that kind of cultural dislocation and prejudice?
Yes, I am. Less so the fishery settlement process, but certainly Te Ture Whenua Māori.
Can you elaborate what that means for someone who is Māori, has been adopted, but cannot actually claim ancestral rights or benefits?
Mm-hmm. So if you can't locate yourself and be part of the life of your hapu around a piece of land, then the relationships that come from being involved with that land are not formed. So one might intellectually know that they're part of Tai Whakaia, for example, or Pūkiko, but unless one is actively involved and recognised in that process, then it's a name, but it's not a relationship, and that relationship is what whakapapa is.
And there's actually case law, there's actually been court cases, hasn't there, that have determined that without independent validation or verification from an ancestor, you cannot actually claim entitlement.
That's right.
Are you familiar? Is there any personal experience of that?
Yes, there is. So I was fortunate, though, that before my aunt passed away, she was able to make a statement to the court that she knew my mother, and of course my father, her brother, and that she had heard some years later that my mother had had a baby to my father, and that I was that child, and so that was what I needed. But if my aunt had died before I'd got that statement, I would not be able to succeed.
And inquiries, I'm going to move to your report, that disconnection becomes permanent, doesn't it? Because, of course, the native land court, now the Māori land court, Kiwibank, becomes the place of your entitlements to your land and to your whānau, to your couple's origins, and of course it's that basis for treaty settlements. Why is it?
That's right. It is permanent. It's permanent not only for me, but for my descendants as well.
Now, in your report, and I only want to focus on pages 182, 183, and 184. First of all, it's a long time since I read it, but I want to acknowledge the women that were part of the team. The late Julia Simpson, the late Kiwibank, certainly Māori women extraordinaire. They were stateswomen in their own right, founding members of the Māori Women's Welfare League with Dame Mira, and devoted their lives to child welfare. So I'd just like to acknowledge them. And then I looked that you were reporting to Dame Elizabeth Mucci. So she was another great woman of the Māori world. So this report, I think, given it came after Puao Te Atatu and the Children, Young Persons and Their Families Act, would be seen as a milestone in the Māori world in the way it was constructed, biculturally, and to whom it was reporting to, and from, I think, with mana from Te Ao Māori or Te Ao Wahine Māori anyway. Would that be fair?
That would. Thank you.
Now, you talk in there about the last resort justification, and I just want you to think perhaps it's now moved to the first resort justification, and I'd just like your comment.
Yes, so I don't have the statistics in front of me, Annette, but the number of Māori children who were placed in institutions when this report was done in 1992 are tiny compared to the numbers placed now. So what we've seen, so despite the report and despite the mana within which this report was regarded in the Māori world, there hasn't been a change. In fact, there's been a worsening of the situation. So the burden absolutely falls with Māori. Because at the same time, the number of Pākehā placed out of family care has reduced. So we've got increasing disproportionate numbers of Māori children being placed in out of care arrangements. I looked at your recommendations, which were to try and put a pathway, which I'd like you to take, which is in page 183. There's two kind of sets. So your recommendations really, I thought if they had been put into place, certainly they were received by the Human Rights Commission, and then who were they given to after that? Because these recommendations seem like good steps to avoid where we are today. So I'm just trying to figure out why. So my understanding was that the Human Rights Commission presented the report to the ministers, so that would have been social welfare, justice and education in this case. I think that's right.
So a theme in the report, which is then developed at the bottom of page 183 and 184, is tino rangatiratanga. Of course, we contextualise the report post or Te Runanga Iwi Development Act and some of those social developments that were occurring between Māori and the government. But a strong theme is that Māori were seeking control over and care for their children.
That's right.
and using the vehicles of iwi development options of an iwi authority or a runanga at that stage for structural dimension to be enforced at that. How come that hasn't happened? Because, I mean, even whānau ora now, if we look at it, and that's what I'm trying to look, if you can guide us from this report to now, what have been the barriers to implementing that, given that it was signalled so early that this kind of structural relationship was required?
So thinking about the barriers that governments face, that would be the vote. So governments, ministers want to retain their seats, and in a racist New Zealand, it takes an extraordinary minister to go up against an electorate, which most of which would not support Māori control.
But a humane society, if we can move it from the discourse of governments, society, communities, would surely want, as your report recommends, people to be adequately refunded, to be adequately resourced, to ensure the full potential of young people and children is able to be obtained. Would you agree?
Yes. Logically, one would think that people do cost-benefit analyses, for example, and it would seem, apart from the humane angle, that even if you went down the cost-benefit line, that it would be beneficial to put resources in early into whānau. But let's not forget the machinery that operates in terms of prisons, in terms of state institutions for so-called care. Those are machinery, and our people fill those and provide jobs for people, for other people, not ourselves, and profit.
Given our discussion, it strikes me, if you look at some of your recommendations, it was matakita, it was a forward-thinking report. It contemplated the tyranny of democracy, if I can use that term, but it actually gave practical steps based on mutual respect and understanding, and the pua o te atatu understandings as a way forward. Do you think those are important flagships or moments in time that should be guiding this inquiry?
I think this is the opportunity that the Commission has, which is to put things back on track and to stay clear of tinkering around the edges of control and power and legislation, and actually go back to even the recent work on the constitutional review, to go back to that work and start to look at how we might pull together the threads of our country so that everybody benefits and that the burden is not with Māori.
And where is the place of te tiriti or the values of te tiriti in that?
That's the framework. Te tiriti is the framework. If we ignore that, we'll reproduce this situation in 10 years' time.
Thank you. I have no further questions.
Thank you, Ms Sykes. Any other council? Thank you. Colleagues? Any questions of Dr Green? Dr Erueti?
Tēnā koe, Ms Green.
Tēnā koe.
Ki te mihi ki a koe.
Aye.
So my name's Andrew Eruiti. I've got a couple of brief questions. I wonder whether, just on the subject of adoption, your views about whether it could have made a difference if, under the Adoption Act 1955, there's no scope for recognition legally of whāngai. And that's been the case, as I understand it, for most of the 20th century. But if there had been, within that Act, recognition, legal recognition, acceptance of practice of whāngai, whether that might have made a difference for tamariki Māori who ended up being placed in forced adoption.
It may have made a difference. I'd be reluctant, though, to suggest that the state become involved in the whāngai process, because, of course, it wasn't. Whāngai, the practice of whāngai was something which was which whānau and hapu practiced. So I'd be very reluctant to extend the power of a state into that domain.
Okay, kia ora. And my final question is about your experience, your personal experience with your niece, and you describe in paragraph 44 the intervention of Te Whakaruruhau as providing sort of wraparound support that you thought your niece and her children needed. Is that the type of intensive sort of wraparound support that you think is needed to be provided to break the cycle, if you like, keep whānau safe?
We're still talking. I mean, Whakaruruhau provided excellent support for our whānau at that moment, but we're still talking about an ambulance at the bottom of the cliff. So I would really like to see the span of interventions sort of going right back and right across the social and economic domains, so that we didn't have situations arising. But given that we haven't, then that intensive wraparound service with high-level strategic arrangements between the chief executive of Te Whakaruruhau, the police in the Waikato, Oranga Tamariki, helped to provide some stability within which some healing could take place. But it was important that those systemic issues were addressed, not just so that the focus wasn't just on my niece and her boys, but that we had some understanding at the high level of organisations that were involved in their case, that there was an understanding there about what the family required, what the direction was, what the practices were that would support the whānau. Kia ora.
Kia ora.
Sure. Tēnā koe, Alison, and thank you for such a powerful personal story combined with your intellectual and academic knowledge and your traditional knowledge of Māori tikanga, and it's much appreciated. I wanted just to turn to a small part, and if you don't feel comfortable answering these questions, please say so, because you've only glanced at this issue, but it is one that comes within our terms of reference, and that is the plight of the unmarried mother who in our Waomua had a very tough time, and I think maybe your mother was one of those. Would that be correct?
That'd be correct. Yeah.
Do you mind just briefly giving us some details about it? I mean, please say if you don't want.
No, that's fine.
Thank you. Could you, first of all, how old was she when you were born?
She was older than my father by a year, so
Roughly.
She was 19.
Yes. She was just a girl.
Yeah, she was. So the stigma that women experienced, and it's women here that are experiencing the stigma from society, but the stigma that they experienced was awful. It followed them in many cases to the grave, and it affected affected their families and their position in society. And so those were so my mother was a cleaner in Rose Albion Hospital, maternity home on the North Shore. She cleaned and had her board for free in return for my adoption.
And that was what I was really wanting to hone in on. Did she become the cleaner during her pregnancy in order to sustain herself and then come towards the adoption? Was that all part of a package, or was she already a cleaner there? No, she was not a cleaner. She approached Rose Albion looking for a place where she could hide, essentially. Exactly. And in return for hiding her and arranging the adoption, she cleaned. And she gave birth to me outside in a hallway, unattended. She was told to keep her voice down because the married mothers would be distressed, and she was alone. It's a very sad story. And you say that it was the nursing home and the Department of Social Welfare which arranged the adoption. Do you know any detail about that? How that was? What kind of detail? Well, I'm just wondering how the nursing home became involved with this. I mean, I can sort of understand the state coming in, but the nursing home, do you know anything about that? Yes. One of the cooks in the kitchen knew of a family who were after a child, and told the nursing home of this family, and they contacted social welfare and made the arrangement, and it was to that family that I went. Thank you very much for that piece of detail, and just signal that that is an area that well within our terms of reference, and we are looking for, I know the stories are there, so it's important to grab them when we have the opportunity. So thank you very much indeed for adding that piece of information for us.
Thank you also just for the courage to share the stories of you and your wider family. The question I really want to ask you is around, you've really been able to articulate very well for us one of the big giants that are lives that fall right within our terms of reference, the systemic issues, and how we deal with that. And one of the things that I gleaned from your evidence is that actually in many respects for Māori the work has been done. The reports that you referred to, Pāo Te Atatu, the human rights report, the low uptake, and thank you to Ms. Sykes for the highlighting of the Manawahine Toa, who was so Māori didn't put their weight behind things, and it's not reciprocated. And so I guess my question really is around, in many respects, it's around the courage to actually revisit those and to implement them. And whether or not that there would be tweaks required for today's context.
You know, thank you for your question. Māori pretty much have been saying the same thing about everything since, you know, for a long time now. So we risk, I think if we don't have regard for the work that's been done and the important information that's produced, then I think the Commission risks a strong backlash from Māori in terms of, you know, we've told so many people this, the information's here already. So I think, you know, kind of need to balance that. And as well, I'd say this: there are some complexities that are here with us right now that we may want to visit. But essentially, and I know that Moana will deal with this, essentially we need to look at what's been produced, what the recommendations are, and I think, and look at how to integrate those into the findings of the Commission, where it's clear that we're talking about apples and apples. If we're talking about a new phenomena, then I think you'll need to take information as it comes to hand through the inquiry and then meld them.
Thank you.
Dr. Green, I have a question too, which arises from your statement just a moment ago of having regard to the work that has been done. If you look at page 7 of your brief, on page paragraph 33, there's reference there to Puo Te Atatu. I have a direct question. Do you think that Puo Te Atatu is fit for purpose for discussion now, again?
Yes, I do. I do. I think that we've now got the United Nations Declaration on the Rights of Indigenous Peoples, for example, that wasn't in force at the time. So there is going to need to be some positioning of that document relative to our current situation. But I think it's a powerful report, and I think that there are components of that report that most Māori leaders will support.
Thank you. Thank you for your evidence.
Thank you.
It seems, Mr. Merrick, that this might be, although a little early, a convenient time, if you don't have any further questions, to suggest that we have the afternoon break now.
Agreed, sir. Thank you.
Thank you. Madam Magistrate.
Kua heke tēnei nohoanga, tēnā koe e tū. The sitting is adjourned. All stand.